Good day, everyone, and welcome. My name is Dan Sampaio, and I'm delighted to open today's Mondac webinar in association with Gun Plus Partners for World IP Day and a highly relevant discussion between Atkinson and Ashley Weiss-Erlu. Has been a partner at Gun Plus Partners since 2003 and co-chairs the firm's intellectual property practice and the technology, media, and telecom industry practice. Intellectual property practice focuses on trademarks, designs, and copyrights. Prior to launching Weiss Law LLP, Ashley worked with Fortune 500 companies, including Benefit Cosmetics, Western Digital, Tory Burch, and Louis Vuitton. Today, she's now advising as an attorney for several businesses that bring innovative products and services to the market. Ashley's committed to supporting the tech industry. She spends her free time working with early stage companies through 500 startups and is the Chief Legal Officer for Women Tech Network, an organization with over 100,000 members. Ashley's regularly featured in globally recognized publications, with her most recent being The Guardian, NBC News, and NASDAQ. Now, before I hand over to the panel, a housekeeping item. You are able to submit questions to today's panel by typing them into the questions pane of the toolbar on the right-hand side of your page. You can submit questions at any time, and we will endeavour to answer as many as possible during our Q&A at the end of today's session. It's now my pleasure to hand you over to and Ashley to begin. Thank you.
Thank you very much, Dan, for this very kind introduction. And welcome, everyone. My name is Aktekin, as Dan introduced. And Ashley, would you like to greet everyone as well?
Hi, yes, it's an absolute pleasure to be here today. I was really excited when had invited me, and from being an intellectual property lawyer for 8 years now, there's nothing I find more exciting than chatting about this topic.
Excellent, thank you. So we are going to around 45 minutes discussion. We will plan and handle the questions within the last 15 minutes. That's the plan, of course. And in the first part of our discussion, we are going to more focus on Ashley, her own practice, and how she used IP as an innovative tool in building her own practice. So in the second part, we are going to from our experience, talk about how young entrepreneurs, young creators could use IP in founding and building their businesses. So in line with the theme of the conference, in line with the theme of the World IP Day, of course. World IP Day this year has chosen the theme as the youth and IP innovating for a better future. So the idea behind this is let the youth, young people, young entrepreneurs more about IP and learn the pitfalls that how they could use IP in building their practices. So I believe that today's key speaker is Ashley, I think, because Ashley herself makes really a good example of how she used IP as an innovative tool by building her own career within the last 3 years. Of course, she has a background as an IP practitioner, but within the pandemic term, she had the courage and challenge to found her own practice. And while building her practice, with the help of IP and the advancement of the digital world, digitalization, she created an interesting practice. And here, I would like to give word to Ashley and tell us more about her practice. Thank you, Ashley.
Yes, so I started with intellectual property starting in law school. I knew I always wanted to work with businesses, and businesses, one of the top valuable things that they have is intellectual property. So whether it was writing papers or getting my intellectual property specialization in law school, I was even my trademark professor's research assistant. So I really took every opportunity to get involved with intellectual property. From there, I immediately began working with in-house intellectual property, doing brand protection, so focusing on the trademark aspects. And over my time spent with these very large companies, it moved to trademark prosecution, to copyright registrations, to disputes, licensing, and then it evolved into being a product counsel, which is very heavily focused on the intellectual property aspects. Fast forward to today. So I now have my own law firm. With COVID, a lot of things changed. We had the opportunity to see the world make an overnight shift to online. So we were taking our meetings remotely, we were engaging with clients in a new way. And I had taken this opportunity and created my own law firm. So my law firm is completely remote. I work with small to medium-sized businesses, and I focus on intellectual property and commercial law. So all of the agreements, which also contain a huge portion of intellectual property as well.
Yeah. Thank you, Ashley. I think, with the kind of opportunity with this distance remote working, you are serving the clients from a distance as well, right? You not only remotely from home to the clients in your country, you're working from Turkey, and the clients are mostly coming from the States.
Exactly.
Yeah.
All of my clients are US clients, and they are emerging companies. So small to medium-sized technology companies, primarily based out of the Bay Area or East Coast, so really hot spots for growing technologies, simply because I was in San Francisco for 14 years, and this is just what I know and love as well. But they wanted an attorney who can be flexible with their own business structures, which are really, a lot of them are, some of them are 100% remote now.
Yeah. Yes, and you're also advising clients in mostly startups, as you mentioned, and within the startup businesses, I see that technological companies are always in the front, and with the with the discovery of, let's say, NFT and the new developments like Metaverse, Facebook changed the name to Meta, and Metaverse is developing. So could you please tell us more about these areas, these new areas, in particular NFT, what is really an NFT, and how we could connect it with intellectual property?
Sure. So to start with my clients that are within the NFT domains, so NFT, it's a fairly new technology. It's actually started to get buzz in, I think, 2016, 2017 with CryptoKitties, but it really started to get attention over the past couple of years. I think COVID may have had a big impact on it because NFT art or images, they give the opportunity to have an individual associate themselves with an online identity. And with COVID and everyone shifting online, it was a great opportunity for this type of technology to grow and give ownership to people that want this type of digital asset within their wallets or their collections of portfolios. When it comes to NFT and intellectual property, there is a lot of room for clarity and education within this domain because it is a new technology and it can get a little confusing. So how I like to explain NFTs from a legal perspective is when we're talking about NFT artwork or images, we're talking about two things. So we have our non-fungible token and we have our artwork. And in the middle, it's a smart contract. A smart contract is not a legal contract. It is lines of code. And these lines of code are directions to the technology that it will do certain things. So we have our non-fungible token, we have our artwork, which is probably on the IPFS system, and a line of code that is now minting it together to create our NFT artwork. When we're talking about intellectual property, we're talking about that artwork piece, because intellectual property is protecting that artwork, similar to one of the pictures in Ura's background. It's just in a digital form. So that is a high-level overview of NFT and intellectual property.
Excellent. So to me, what make your practice different is that these areas emerged, within the last 2 years, within the pandemic period, and then you started your own practice, and you found yourself in the middle of this area, and then by using your copyright and copyright experience, I believe, you immediately grasp this new area, and you're working on these. So what are the common issues now we are facing on the NFT world in terms of intellectual property protection? And also, next, I will have another question about the enforcement of IP rights in relation to infringements in NFTs.
Yeah, so to your point, it aligned NFTs and intellectual property just aligned very nicely with my background in intellectual property. So if there is an attorney that specializes in intellectual property, NFTs is something that they could support with. Since it's a new technology and there's a lot of education that needs to happen around it, there aren't that many attorneys that are well versed in it. So a lot of my NFT clients have struggled in finding an attorney that knows the technology, because as with most clients, the client is attracted to someone that knows the business, because beyond just providing ad hoc advice, they're looking for someone that can support building a legal foundation and a relationship with someone that knows the business. When it comes to the types of intellectual property that surround NFTs that I'm working on, it is copyright. A lot of it is copyright, and they're interested in ownership, because there is confusion on what a subsequent purchaser of an NFT actually owns. So if I created that NFT, right, and then I sold it to a subsequent purchaser, that purchaser owns the NFT, but that image, they only have a license to it. Unless there's something else in writing, about 99% of the time, it's going to be a license that subsequent purchaser of the NFT has purchased. And so that's where I see a lot of questions now, and I think we're going to continue to see questions in that aspect with the licensing and the ownership as this education continues to evolve around NFTs.
Yes, and coming to the enforcement, as far as I know, almost 80% of the NFTs sold in the platforms like the famous one, what was the name, Safe?
OpenSea.
Yeah, OpenSea. Most of 80% of them are like not unauthorized ones. So how would you enforce the rights of an intellectual property copyright owner against one unauthorized using it in an NFT?
So I'm really glad that you brought this up. There's a lot of money right now with NFTs. Some of these are going for multi-millions of dollars. So there is money that's being made with bad actors. So where money is being made, whether this is, let's bring it in a real life example of a Gucci handbag, you see tons of counterfeits. We're seeing a lot of money being made with NFTs, so we are also seeing a lot of counterfeits. These are bad actors that are stealing other people's artworks and then reminting them and then selling them on OpenSea. OpenSea is the most popular platform to buy NFTs, which is why we're seeing a lot of counterfeit on there, because the consumer's there. That's where the counterfeiter wants to end up selling these types of NFTs. So when it comes to enforcement on platforms, each platform is going to have slightly different procedures on how you can remove that infringement. With OpenSea, it's similar to what I've seen on maybe a Facebook or an Instagram DMCA takedown notice. It's a web form that you fill out. But where I think we are going to see some difficulties is there's likely a large influx of reports going through these platforms, and they have to balance whether it is someone that is making a report that is actually an infringement, that so the reporting person actually owns that copyright, versus who is the one that is now placing that NFT up for sale on OpenSea. So I think we're going to see more disputes and a more need for intellectual property support in that regard.
Yes. So investing in Bitcoin or blockchain, let's say Bitcoin, NFT is a type of Bitcoin. It's true, right? It's kind of, but this is non-fungible, not fungible, non-fungible thing, non-fungible token. So I'm an investor. I want to invest on NFTs. So what I need to do to own a genuine NFT, which is cleared in terms of copyrights?
Yeah, okay, so if you wanted to buy an authentic NFT, you would want to look at, I'm blanking on the name, but there is a website where you can see all of the transaction history of that NFT, who minted it. So you'd want to make sure, like if you're going to buy a Bored Ape, that the transaction history aligns with the Bored Ape that you're actually going to buy. So if it's a very expensive NFT, you will want to do your due diligence to make sure that you're not buying something from a bad actor, someone that has stolen something and resold it. Yeah.
And the other thing I heard is that with the help of NFTs, copyright holders will more securely collect their license fees, or because they will easily track the history behind it. Is that correct?
Yes. So I think NFTs are absolutely an amazing technology for digital artists because it gives them the opportunity to show ownership in a way that had been a struggle before. And I want to give an example of when I used to work with artists at one of these very large companies that I was at. They would find beautiful digital artwork and they wanted to incorporate it into an advertisement, something that may be going on a billboard or product packaging. And oftentimes we were up against the problem in that we didn't know who created that artwork that we're now finding on a Google search. And we weren't able to use the artwork because we couldn't ask for approval. We couldn't give them money, the artist money, to use that artwork. So now what we're seeing is we have that ability because we can now track down who the owner is. When it comes to licensing, not only can we track down the owner because it's all it's like a ledger on the blockchain. All of the owners are going to be recorded. So whoever minted it, we now know who owns that artwork. It's actually written. It can be done a couple of ways, but it can be written into the smart contract, or it can be, if you're minting it on a marketplace, it can be the royalty provision can be identified and minted therein. And you'll see each subsequent sale, the owner will get 2.5% to about 10% max of whatever the subsequent sale price will be. So not only do we have ownership in case someone wants to use that artwork, but we have these royalty provisions that is also going to be helping out the artist, incentivizing them for the creations that they're making.
Yes. Yes, as you know, this area is very fastly developing NFT area in relation with copyright. So we are going to see many new things, I think, as they pass this. And also, let's talk about more on metaverse. I mean, metaverse is also coming up, and we see, news like you purchase some land in a metaverse, or what are the story behind it in terms of IP?
So I'm so excited because I even think I overheard that there was Turkish or maybe Istanbul land you could buy, and maybe it's Sandbox. I might be saying that name wrong, but it's a really interesting concept. So the metaverse is going to be several different types of metaverses. To your point, or you mentioned Facebook is now Meta. They're doing this brand change direction with their company, and they're going to be coming out with a metaverse. We're going to see this. There's already a few of them. I think there's one with Snoop Dogg has his own metaverse. And what this is going to look like from an intellectual property perspective now with I think it's Sandboxing, and I'm blanking on the name. And in the future is if we see someone using intellectual property and they don't have authorization, it's going to be similar in that we can enforce against that intellectual property. To enforce, though, we would have to show ownership. So whether that's a copyright or a trademark, we're going to need a registration, especially for the trademarks in particular, and then the ability to show that we actually created that copyright to show that we are the owners of that too.
Yes. I think one of the issues that will come is, which jurisdiction you register and where do you enforce your rights. That will be an issue. There are some cases pending, I understand, in the States. And also the other thing, whether you cover in the metaverse, like NFTs, your specification, your trademark covers those goods, and how would you argue confusing similarity? These are the new issues as with the metaverse, I think. I know that many companies now broadening the scope of their trademark protection by adding new classes to their trademarks to cover the digital items, NFTs, and other digital software to be able to properly enforce their rights in metaverse. And also, even without registering, it may be considered, to enforce, because possibly depending on the use and whether it causes confusion among the public. But how would you advise the businesses in the technology while registering their trademarks? Should they cover those, or how would you advise?
I think that's a really exciting point that you brought up with the jurisdictions. I would say to align the strategy with what you have outside. So if it was a real world product, let's say you're selling in 31 countries, but you also have defensive registration. So maybe you're filing and you have a strategy of 50 countries. I think you should be considering expanding to those international classes that are going to be within the covering metaverse, and also thinking about those jurisdictions where the metaverse is going. There will likely be a very popular metaverse. So we have Facebook in the US. We're definitely going to probably see something big over in China. The Eastern European region is very, very popular when it comes to blockchain and crypto. So we're going to see other things going on with NFTs and likely metaverse over here too. So expanding the filings in jurisdictions where we can also likely anticipate that there is going to be a huge presence when it comes to the metaverse as well. Yes. So a little bit of defensive, and then also defensive filings, and then also where we're planning on, where we already have a footprint is where I would strategize.
Yeah. So as we see, these metaverse and NFTs are very well connected with, copyright, intellectual property, in particular, copyright and trademarks. And that really overlaps with your private practice, where you focus with the startups and technology. I believe you see a lot of transactions going on, and also a lot of enforcement need in this field. How would you describe the most important need to maybe regulate this area in terms of international or national jurisdictional levels? What would be the most important? Is there a need for a new regulation, or if there is a need, what is the most important one, would you say?
In terms of regulations or laws that are applying, intellectual property regulations or laws that are going to be applying to this new technology, I do think that we have law that can be applied to it now. But as with most laws, it does not really keep cadence with new technologies. This being a new technology, we're going to find struggles of legal application, and that could be in different jurisdictions also. We might be trying to stretch application, and as an intellectual property lawyer, I think we are some of the most creative attorneys because we are always looking to the facts and then applying the law to those facts and seeing how it can support our client. In the future, I do think we're going to see new, from a US perspective, we're going to probably see new legislation that will attempt to be passed. I'm not sure in what domain, specifically with intellectual property, but the reason why I think this is going to happen is because it tends to happen with other technologies that we've seen in the past too. The law just tries to keep a natural cadence with what may happen. And I believe there may be some change with the DMCA and how that will move forward, but it's really me just being predictive here.
Exactly, yes. Now, let us be more specific and come to the theme, the World IP Days theme, and how young entrepreneurs, creative people could use IP in creating, building their work, their business. So some more real life examples we could give as well. We are talking about trademark and copyright perspective in this panel. We are not touching base on patents. It will be dealt with another panel 2 days later. But in relation to trademarks, I would like to begin with maybe in terms of trademark and copyright issues. A person, an entrepreneur, should be definitely consider, making use of the IP. Intellectual property has become the biggest asset of a business, and so an awareness definitely should be there. And then within the scope of that awareness, one should definitely work and see which areas of intellectual property his or her own business touches upon. For example, if it's a technology company, copyright would be the most important intellectual property right that the entrepreneur should focus, whereas trademark should be in all of them. But when it comes to consumer products, consumer touch, trademarks becomes much more important. And also, depending on the, again, business, for example, if you are doing something in plant varieties, which we don't cover today, but plant variety rights are a type of intellectual property right, is becoming more important. So it is important to discover what intellectual property rights are in your circle and what should you do to protect them. The first thing I think should be this one, and then after discovering, one should start with whether a registration is needed or not. For example, in copyrights, in many countries you don't need a registration, whereas for trademarks it's a territorial intellectual property right. You need to register in all the countries you are going to conduct business. Maybe in terms of registering trademarks, you could make a plan and register in the markets, in the countries that you are going to focus in the short term, and then delay registering in those that you'll focus in the mid-term or long term. But still, it is important to revisit this decision over the course of your business, because I'm mostly practicing on trademarks, and one of the issues that I see in terms of international businesses, they omit registering their trademarks without knowing how they become a big business, without maybe becoming conscious aware of that, and they forget to register in some countries, and then the problem starts. So it's important to register your trademark when it comes to trademark. And on the copyright, we say that there is no need maybe for a registration, but you need to document your rights when it comes to trademark. You need to create a written evidence of ownership of your rights, and you should use it in your business. But it all starts with, what is my right and how I protect in the beginning. So I talked in general about trademarks and copyrights, but to begin with trademarks, for example, other than registration in the startup of a business, what would be your other recommendations for a startup?
I think you brought up a few really good points, because I've seen in my practice, it's very difficult because you want to protect your intellectual property. And sticking with trademarks, for example, it's a lot of prediction that may be going on when you're trying to strategize your portfolio. And you're choosing these jurisdictions that you do need to file in if you want to enforce or even sell. Sometimes you need a registration to sell in certain countries. So a lot of it is having, and this goes perfectly with the theme today too, because it's innovative founders or young entrepreneurs that are now kind of strategizing how they're going to even be doing a trademark portfolio for their new and growing companies. So it's thinking long term, having a long-term vision of where the company is going to be in 3 months, in 6 months, in a couple of years, and what that growth looks like, and then aligning your intellectual property or your trademark strategy so that it's in tandem with that. So here's the other thing too. It's cheaper, and I tell this to my clients, it's cheaper to get the registration now than to fight someone who has had the foresight and is now registering in Turkey, Morocco, China, and now they've got your trademark, and you're in this position where you're negotiating with someone who knows the value of this intellectual property. And so it's a lot more expensive than filing a registration in advance.
Yes, I think as you said, use. The other thing is, you need definitely an advisor. And for example, manufacturing in one country means also use, even if you don't sell them. So I see many businesses, oh, we don't need to register that because we're only having somebody manufacture for us, but you're using when you manufacture that. That's important. The other one is always, the coverage of goods and services, as we discussed during the first part. It's important that you cover all the related goods if you're doing business on goods, and also services. Otherwise, you may have difficulty in that regard as well. So, as you say, registration is first important for trademarks. But as the business grows, I think once you register trademarks, protecting it's equal, even more important than registration sometimes, because if you don't protect, then it may even be diluted, and it may be in a generic word. There's a genericism threat as well. In that regard, from your brand protection experience, would you like to add more?
Well, I did want to touch on one point, because I think you're bringing up a really good point in that we've got these registrations for protecting, but then also we're monetizing our intellectual property too as the business grows. So registration is always one of the top questions that I get from my emerging or quickly growing clients. And then in tandem with it, the next thing is, we need to make money. Because a growing business I think that's the #1 priority also for any business. You want to protect what you have, and using software, for example, you want to be able to protect not just the company name, but also the product that you've spent a lot of time and resources in developing, but then also making money off of it. So where I'm also seeing intellectual property is within these agreements for for example, software as a service. We're licensing the software that's been developed there, and there are very important provisions within these agreements that are protecting the intellectual property that has been developed, whether that is, making sure that it's only a license and only certain rights are being given to the licensee, and making sure that nothing is going to be impacting that intellectual property, whether that's, putting verbiage in there that says you can't reverse engineer or use the exact same types of technology, those types of provisions.
Yes. And yeah, you came to the point licensing apparently, and thank you for bringing this discussion to there. And you're making money by licensing your trademark even in the areas that you don't use. If you create a famous brand, it doesn't need to be a brand even in the businesses, regular businesses that we know. For example, we are aware that many universities has a brand, and many soccer teams, basketball teams has a brand, and they really make use of those brands by registering and licensing. And the issue that I would like to come is also in terms of better protecting your rights. You need to monitor the registries around the globe, monitor them, and oppose to confusing with similar applications, or even enforce your rights against possible infringers. Because as you, if you don't clear the register, if you don't act against the people infringing your rights, after a while, you may kind of, your trademark might be diluted if it's a very strong trademark, and it will lose its value of identifying goods and services of your entity from others. So that's one of the biggest problems, I think, in terms of trademark protection.
Yes, and in order to monetize, we have to have those registrations in line too. Another thing you don't want a company to be in is in a position where if they aren't monitoring those registrations, is that company is now limited in expanding unless they want to buy the expanded registration. So let's say I did have that handbag line, and I think that's 25 or 18, I don't remember at this point. But let's say I wanted to start selling keychains or cell phone cases, but someone else has that registered, and I just wasn't being proactive or using someone to be able to search and give me a notice that this is going to be a filing. You're now limited in either what you can sell or produce with your own trademark. Or, I mean, we all know that there's other ways to kind of get around that. Maybe you could argue, oh, it's a natural expansion, but that's a lot of money. Now we're talking about a lot more money than just a simple filing that could have been at the beginning.
Yes. Now coming to the copyrights, which is more relevant with the creativity. Do you recommend your clients to register them in other countries, or how would you advise them to kind of create an evidence to show that they are the genuine owner of that right?
So I think these are great points. It depends. Generally, so within the US, generally I don't recommend filing a copyright registration, but there is something along with damages. You have to have a registration. When it comes to evidence, I'm so glad you brought this point up, and I wish I had touched on it earlier when we were talking about NFTs, but the blockchain is a ledger. Everything is visible on there. So if you have an NFT that is being sold by a bad actor and you wanted to get damages, you can go in and see all of the transactions that NFT has been sold. So how many people bought it? How much money was it for? And so you're entering a totally different story with a demand when you have this type of evidence, when you want to claim a certain amount of damages. This is a lot more different than, let's say, a counterfeit seller that we're now finding even online. I had struggles with this on eBay because they have multiple accounts. They're selling all of these handbags. It's a lot of prediction. So evidence, I think we're going to see change more when it comes to the digital assets. And it's going to be a really exciting thing to see how that plays out.
Yeah. Yeah, the other thing with the copyright is that, compared to trademarks, I found it more akin to patents actually, because a copyright could be a backbone or the real business. Of course, trademark is also very important. A brand, there are, multi-million-dollar brands, but you can change the trademark. You can find a new one. But if you are, for example, a technology company, you have a software, and you protect your main protection tool is copyright, like patents. In that way, they are similar to each other. So I think depending on the business, copyright, as I saw, could be the main item that a business owner could rely upon. For example, in technology field, we know all that software are protected in many countries under copyright laws. It's not a traditional copyrighted item, but they are protected as under the copyright laws. And you're working more on technological companies. In terms of creating the copyright, as we talked, it's easy to evidence, and it's easy to argue copyright. But in terms of building the business, making money, how would you use copyright in the software and through licensing, of course? And what are the issues that an entrepreneur should be care on while doing this?
So when it comes to my clients that are within the software domain, they aren't registering for a copyright, but they are making sure that the intellectual property provisions in their software as a service or sales agreements services, they are making sure that they are protected from an intellectual property standpoint. So let's say this is a services agreement that we're working on. If there's going to be any type of intellectual property that is going to be developed, it's very important to identify who's actually going to be the owner of that intellectual property. If maybe the person or company that has developed it is, maybe they're going to be licensing that technology. When it comes to the copyright registration of the software itself, it's very difficult for my clients because a lot of it is open source and it's fast moving. And it's not necessarily in the ethos of the companies that I'm working with. So the focus there is really making sure that the licensing portion, which is the first part of the agreement, it's very important, is going to be aligning with their business strategy and not going to be limiting them in their growth.
Yes. And the other thing with the copyright law is that there are works that you wouldn't maybe imagine, oh, it's protected under copyright laws. For example, I see this intersection with the trademark protection as well. When you are protecting company logos or cartoon characters, they are also protected under copyright law. And by dual protection in terms of trademark as well, you could easily build a case against an infringer. So it's important to know whether you are protected under copyright laws or not. And another thing, I see that many businesses that are based on copyright protection, especially in the film industry, like cartoon characters, etc., after certain a while, copyright protection ends. It's not perpetual like trademarks, provided that you renew it. So I see a common trend that these copyright protected characters becoming trademarks after a while by registering them for the relevant goods and services and enjoying protection for a lifetime as soon as you renew them. That's an interesting point to make in terms of intersection. So these kind of issues that young entrepreneurs should be aware of while basing their business on copyrights, trademarks, intellectual property, and there are various intersection and overlapping provisions I want to point. So in terms of licensing, I think licensing, when we say copyrights, licensing is the most important tool to make the business grow. what are the typically main, issues that a licensor, as a copyright owner, should be taking care while licensing its work or software, whatever?
Yeah, I think for one of the big things to watch out for is any terms that are going to be limiting your use. So if I'm a growing company, I want to be able to have anyone license my software, because more people licensing it, the more money. I don't want to be restricted to a certain jurisdiction. I don't want to be restricted so that I can't sell my software to someone that may be a competitor or within the same domain. For example, let's say my software supports mobile bikes, e-bikes, or e-scooters. We see Marte everywhere. If there's a software and I'm creating that, I want to be able to provide it to the other scooter company too. So making sure that those provisions are not limiting, and then also making sure that they are limiting in certain ways. So someone can't license the software and then subsequently sub-license it to someone else. Maybe they're doing it at a fee that isn't conducive to the business structure that I have formulated. And I would just prefer to have that relationship myself as a software owner. So those are terms that just immediately come to mind that are something to keep track of during the drafting of these agreements.
Thank you, Ashley. We are going very quick. I think we almost come to end of our conversation. We have a number of questions, so I would like to jump into the questions for our last 10-15 minutes and see what we have. One of the questions is, what are the roles of the World IP Organization in ensuring a green, innovative future? I'm not that aware any initiatives by the WIPO. Do you have it? Are you aware?
No, I don't have any comment on that one.
Okay. And the other question, what impact would the transfer of NFT ownership have on development of the law on copyright ownership?
So I think this is a question that's hinting at, and if I'm wrong to whoever has asked this, please chime in. But when it comes to ownership of an NFT with that subsequent sale, that purchaser does own the non-fungible token. They don't own the artwork unless there's an assignment attached to it, which is not usual. It's very rare to see that. So that ownership of the NFT is with the non-fungible token, but not the image. It's a license. And usually that license is, unless it's in writing otherwise, it's just for your own personal use. So if I bought that NFT, I can use it as my social media avatar. I could use it in my own metaverse. I can't go and put it on cups or t-shirts or a billboard or sub-license it to someone else to make money off of in a YouTube advertisement, for example.
Yes, actually there is another relevant question, maybe you already answered, but does buyer of an NFT has right to make copies of the artwork therein? Does it depend on what the smart contract provides?
Great question. So yes, it depends. So if you want to see what you own what rights you hold when you're buying an NFT, my advice would be look at the terms of use on the website of the artist. That would be the first place to look, and it should provide the license rights that you hold. Quite honestly though, I would say 90% of NFT companies don't have this yet. So this is another growing area that needs support from intellectual property attorneys, are these license terms. Will you see it in a smart contract? Probably not. I've only seen this maybe once, and I've looked at a lot of these. And the reason is because it's usually a tech person, that like an engineer, someone that's minting the NFT via the smart contract. And you would need to have legal insight at that early stage of the company And generally that's not happening. But if you are in a position where you are looped in during the minting process, you can put license terms within there.
Excellent. I see a lot of questions on NFTs. There is another one, interesting one. NFT and music, is there any future for these two?
I think yes, and this is just a prediction. I see NFT. So blockchain, it's a decentralized technology. So when we're talking about NFTs and music, we're talking about decentralization of it. Right now, where we're primarily getting our music is we're getting it from Pandora or Spotify, which is a company that's licensing from Beyonce to Billie Eilish, and they're getting the licenses so that now we can subsequently listen to the music. I'm curious to see what's going to happen with that agency relationship and NFTs and music. Are we now going to be getting the music directly from the musician? Maybe. Is there going to be a decentralized platform where, I mean, I remember Apple Music had something where you could only download it so many times. Maybe there's going to be something that is not going to allow that. It's going to have more control in whoever has licensed that music. And again, prediction, but we'll see.
Yes, there is a question again regarding metaverse this time. How metaverse is going to change whole IP protection mechanism? The question is.
I don't think there's going to be a massive change, because it does take a lot to even introduce a bill and have it turn into law, and then technology then changes very quickly. We may see different applications of the law, but I mean, I'm curious to see what's going to happen in this domain as well. There's probably going to be some type of, I guess, standardization that's going to be set up, similar to what we see with a lot of marketplaces and social media platforms when we're seeing intellectual property infringement. They all have all the big ones seem to have a similar process when it comes to protecting your intellectual property.
Yes. There is one question which I will reply and give the word to you as well. It is regarding the protection of copyrighted content, including photographs on social media and available enforcement options. Photographs also protected under copyright law in many countries, and so you could protect them by enforcing your rights. The simplest way could be most of the platforms like Instagram or Facebook have options that you could make an easy complaint and take it down. Otherwise, you need to go to regular enforcement options, I would say. Would you like to add something here?
I think this also hones in on having the ability to show ownership is very important too. We talked a lot about getting those registrations and then showing ownership if it's a copyright. Maybe you have a website that shows images of your work, whether that's your company, and let's say you're selling a shoe. Just having that URL will be very strong evidence that this is your copyright.
Thank you. There are two questions which are related with each other. One is, can you please elaborate on the carrier options in international IP law and its feature? And the other one is, I'm not a young entrepreneur, but a middle-aged one. How can you help me continue to stay engaged in IP business? So maybe we could reply these. Please, you can start.
Yeah, for the middle-aged one, I think that's a great question. I would say for me, and it's always keeping up to date with the newest technology. So that could be, subscribing to legal publications. A lot of law firms have blogs, and they're producing content that is very applicable with the types of law that are coming out, and new technologies. and if you specialize within a certain industry, also being a subscriber to those types of publications. For example, fashion, Business of Fashion was a big one, and then there's a few other ones. TechCrunch for quick legal news. So staying abreast with both the legal aspects and also the business aspects within a particular domain would be very helpful.
Yeah. Regarding the second question, maybe I would like to comment first. It's kind of intellectual property, like some areas, I know the tax, maybe the maritime law. It's one of the most internationalized legal fields. So when we say copyright in a country, for example, in Turkey, mostly very similar with the copyrighted item in US, except some, a few different areas. Other than, for example, trademark protection law is also obtained by registration. So it's kind of, the rules are very similar, very similar to each other in many countries, because these areas are regulated mostly in international level with international treaties starting from 19th century. And also within the EU, many countries have almost the same similar laws, especially Turkey, following the EU application process. Most of the laws are compliant with the EU. So I would say that you can easily, as an international lawyer, you can easily practice in other countries in the field of intellectual property as well, provided that you get a qualification for qualification requirements for a given country. Otherwise, you would make a very important asset as a paralegal or legal assistant if you want to practice, start from there. I have a couple of colleagues who moved other countries, and they started as paralegals, legal assistants, but they are also pursuing their education to get the same qualification to practice in there. But the practice is more or less the same, I see, as far as I see, meeting with colleagues in the international conferences. We are almost discussing very similar issues in terms of protection enforcement. And also your views are important as an in-house practitioner for almost 10 years. How would you describe this?
I think intellectual property is a very international type of law. Companies are looking to go global. They're not looking to stay within their own city or their own state or their own country. They want to expand, and they want to expand internationally. So intellectual property is hand in hand because it is the most valuable asset of a company that they are trying to monetize. So his point, knowing a high level overview of intellectual property will be very helpful, as there is a lot of similarities internationally. And then also knowing when to touch on outside counsel that has that local knowledge is very crucial too, so that support is there for your client in a way that is comfortable and confident too.
Thank you, Efşi. And we have 2 more questions, and we are running out of the time. So let's try to answer these questions very briefly as well. The first one is, what could be a tentative roadmap for value creation in IP? How would you like to answer this question?
Ownership, so getting your registration, and then working very closely with your marketing teams, your sales teams, and making sure that you have the legal contract in line to monetize that intellectual property. That'd be my short answer.
Thank you. We already discussed these issues as well throughout our discussion. So, and the last question is in relation to the data privacy. How IP can be used to protect right to privacy and free speech in the times when we are discussing evolution like metaverse?
I see private data and privacy is going to continue to evolve. In the US, We have the CCPA, which is a California measure. We see a few other states, I think, that are coming out with measures in this year, and we're seeing it internationally too. So it's going to continue to evolve. GDPR has set the stage and the standard. So if we can make sure that our privacy and data management aligns with that, we are in a very good starting point. But Turkey, I know, has recently, I don't know anything about it, but I know that Turkey has recently came out with some privacy policies, and it's just very important, not just from a financial aspect to make sure that you're compliant, but from a consumer perspective, because it impacts your brand. With intellectual property, we're always talking about a brand, the brand that we're protecting. This is another way that it's very easy to protect your brand in showing that you care about the consumer and being transparent with how the customer's data is being managed.
Yes, data protection laws after 2 decades finally entered into force in Turkey a couple of years ago, and there we have an authority as well, and they are kind of really being enforced. So in terms of IP, having IP to protect data privacy and the relation between them, I think that this new technologies would help in that regard, in particular the blockchain, and in terms of tracking the intellectual property rights, and also using them while protecting the data will become more important, and we may see new developments in that regard. But as I told you, we are very new to these data protection laws. Also, it was although it was discussed over 2 decades, they just came into force in the last 3-4 years time, and it is a new area also, like the NFTs. The data protection is one of the new areas that are being emerging in our country as well. And the other thing is the intersection between data protection, data privacy, and intellectual property, in particular trademarks. This is also heavily discussed in international levels. I know the 2 organizations in INTA and IAPP that are collaborating closely in that regard, and they are both affecting each other. I mean, the data privacy laws are affecting trademark enforcement activities, from the domain name protection systems, and they are blocking all the registries, etc. But in some way, there are the common areas that they could work hand in hand. So we will see, I think, more alignment between these 2 rights, maybe in international level, I think, in the future. And in this regard, WIPO may play a key role in protection of and also protection and collaboration of these 2 areas, I would say. Well, this is the end of questions. Let me see any other questions. No, we are maybe 3 minutes ahead of our time, but as a final word, would you like to say something, Ashley?
I don't have any more final words, but if you do want to connect with me, feel free to ping me on LinkedIn, and happy to chat about intellectual property. Absolute pleasure, though. Thank you.
Thank you. I also wish all our attendees a good day, and this world, I celebrate all of their World IP Day. Have a great day. Thank you very much. Bye-bye.
Bye.